Your Honor, this is a motion argument scheduled for today. The state's obviously ready to go forward. I would just note that at the conclusion of this hearing, I will need to leave with the court for about 2 or 3 minutes to explain to the victim's family what's going on.
You want me to trail it then, or?
It's your decision if you don't want to wait.
Mr. Schofield, what's your schedule like this morning?
Brutal. How long are you trailing it for?
I've tried to get another deputy to come cover so that we can keep going for those few minutes. There's nobody here yet.
What's the issue in terms of trailing it, Eric?
When we're done, I'm going to need to explain to the victim's family what's going on. So I just was telling the court I'm going to need a 2 or 3 minute recess at the end.
Oh, so we can go forward and then
we can. I'm ready to go
the
forward.
recess after the hearing, Your Honor,
Correct.
if that works for the court.
Good morning, Your
We are
Honor.
prepared to proceed.
Morning. So let's go forward, please.
Mr. Schoenfeld, New York.
Your Honor, this is on for our motion to set aside the ex parte order regarding release of medical records and related witness testimony. What it boils down to is the last paragraph of the order. And that paragraph of the order provides, it is further ordered that any and all medical personnel referenced in the foregoing medical records shall be authorized to appear for pretrial conferences and pursuant to subpoena to testify regarding their treatment of Henry James Ruggs III at all court proceedings. So the order is not just for production of the blood test results. The order mandates that the medical treatment providers appear for pretrial conferences to talk to the district attorney regarding their treatment of Mr. Ruggs and to appear in court proceedings regarding their treatment of Mr. Ruggs. Why is that problematic? Because Nevada has a general rule of privilege found in NRS 49.225. That privilege states a patient has a privilege to refuse to disclose and to prevent any other person from disclosing confidential communications among the patient's doctor, or persons who are participating in the diagnosis or treatment under the direction of the doctor, including members of the patient's family. So you start with the premise that anything you say to your physician is privileged. Then you look to see if there's an exception to the privilege. The only exception that applies in this instance is NRS 629.065, which is the statutory reference in the ex parte order. So what does 629.065 say that the state is entitled to? What it says is each custodian of healthcare records shall upon request make available to a law enforcement agent or district attorney the healthcare records of a patient which relate to a test of the blood, breath, or urine of the patient if, and one of the situations is if the person is charged with a DUI, substantial bodily harm, or death. So the statute allows the state to receive from the custodian of records the written chemical test results and nothing more. So starting with the fact that every communication is privileged, the exception being that they are entitled to the blood test results, that is all they are entitled to. In the first part of my argument where I read the last paragraph of the order, is completely in contravention of Nevada law. So people always say, oh, well, there's a HIPAA exception. HIPAA is the floor. The case law cited in our motion from the federal courts provides that the state is entitled to provide and afford its citizens with additional protection above and beyond HIPAA. That is precisely what the Nevada legislature has done in this instance by implementing and enacting NRS 49.225. We as citizens of this state have additional protections above and beyond that provided for in HIPAA. So we take a look at a case from the Court of Appeals from 2017. It's Vitale versus 8th Judicial District Court, found at 133 Nevada 1088. In that case, the state produced subpoenas for medical records in prosecuting a defendant. And what the Nevada Court of Appeals stated they didn't reverse the conviction in that case or issue the writ in that case because they found that it was harmless error for a reason that doesn't apply here. But important from that case as it applies to Mr. Ruggs is the following paragraph. Although we conclude Vitale has failed to demonstrate our intervention is warranted, we are troubled by the subpoena's broad demand for her medical records and the lack of citation to statutory authority for the release of those records. We therefore urge the district attorney to ensure that all future subpoenas that include a demand for medical records under NRS 629.065, subsection 1, be carefully drafted to prevent potential for improper disclosure of medical records. So now again, we go back to the order at issue here, and what was the statutory authority? NRS 629.065, the very statute that the Nevada Court of Appeals cautioned the district attorney's office to make sure that they narrowly construe that statute. So the order that we have here, Your Honor, which was issued ex parte at a point in time where Mr. Chesnoff and I had already made an appearance on behalf of Mr. Ruggs, goes far beyond the confines of NRS 629.065 and the case law just cited, and it does violate NRS 49.225, the privilege that a patient has with their doctor in terms of compelling communication or even authorizing communication by a healthcare treatment provider of Mr. Ruggs in providing the communications to either the district attorney's office or even under testimonial subpoena. In the opposition filed by the state, they cite NRS 49.245, which includes the exceptions to the doctor-patient privilege. However, the only exception that could potentially be applicable is subsection 4. What that exception states is as to written medical or hospital records relevant to an issue of the condition of the patient in any proceeding in which the condition is an element of a claim or defense, there's an exception to the privilege. That is no different than NRS 629.065. The only condition, so to speak, that would be at issue in this case are the blood test results. And what NRS 49.245 subsection 4 states is that as to written medical or hospital records, there is an exception. The state already gets that as a result of 629.065, where it says that they're entitled to the written blood test result. They are not entitled to anything more, and the order at issue violates the doctor-patient privilege. Finally, the state cites in their opposition the case of Mitchell versus 8th Judicial District Court, which is found at 131 Nevada 163. And they cite that case in support of the proposition that communication between Mr. Ruggs and the treatment provider are in fact part of the exception. However, in that case, the Nevada Supreme Court was analyzing NRS 49.245 subsection 3, not subsection 4, which is what I just read. Subsection 3 is the exception to a privilege when communications are made in the course of a court-ordered examination of the condition of a patient with respect to a particular purpose of the examination. That's for in a civil case where somebody does an independent medical examination. You can't then claim that my communication with that physician doing the independent medical examination is privileged. Totally irrelevant to the analysis in this case, Your Honor. So when you start with the general law that there is in fact a doctor-patient privilege in the state of Nevada, it is the state's burden to prove or demonstrate that there is an exception that applies to the communications between Mr. Ruggs and the treatment providers. No such exception exists, Your Honor, and therefore the order should be withdrawn. At a minimum, the portion of the order where it allows for testimony must be stricken.
Your Honor, I believe I laid out the state's case pretty clearly in our opposition, which I'm certain that the court has read at this point. There's just a couple of additional points that, based on argument made by counsel, that I'd like to make. First, I had some involvement in the Vitale case, as it was one that arose out of our division in our office. I can explain to the court that prior to Vitale, the general procedure followed by the state in cases such as these was to issue grand jury subpoenas for just the defendant's medical records, in general, everything. And that would be from his time of admission to the time he left, and we would get everything that came out of it. Our response to the Vitale decision was to create the format for the order that the court has seen in this particular case and sees in other cases since Vitale, where we limit that to just the relevant information, where we solely order any information that's related to testing of blood, breath, or urine regarding controlled substances. And that's the limitation we put on it as a result of the Vitale decision. Furthermore, I would just note, just more as a general policy issue, counsel's position seems to be that we get the blood results, we get to just issue that, put that into evidence without cross-examination as to methodology, as to how the hospital carries out its testing or anything.
I think they're more concerned about the dialogue between the medical professionals and the defendant.
Right, and the state has no interest in any of that. The only testimony that
So let me stop you there then. So then perhaps we could craft this order to reflect that very limitation and that way we can satisfy both sides. The state could have whatever evidence they deem necessary, not related to privileged information that relayed by the defendant, and then the defendant could have their protections guaranteed under the
Along those
law.
lines, if I could make what I hope is a helpful and constructive suggestion, which would be that the only testimony that the state would seek under this order would be testimony providing context or explanation for how the blood test was done and methodology.
administered.
Right, and this is information that I would think in most cases, the defense especially would have interest in cross-examining. Because just, let's say we were to get a number back that was really high, and we just get to put it into evidence, and nobody gets to question it, and nobody gets to talk about it. That's probably not in anybody's best interest.
Unless we can get the defense to stipulate to it.
We're not going to stipulate, Your Honor, but here's the real reality of it. It's Mr. Rugg's privilege. If the state goes to a grand jury, we don't have these records. If we get the records and we deem that an explanation is necessary for grand jury purposes, in our state, there are protections afforded to a defendant who gets a Markham notice for purposes of grand jury that other states don't provide. And those protections are that the state has to present exculpatory evidence. So if we receive these test results and make a determination that there's something wrong with them, there's exculpatory evidence, they need to be explained, at that point in time, Mr. Ruggs would have the option of waiving that privilege and requesting that testimony be presented. But the way this court order is written, it is a breach of his privilege. It allows the medical treatment providers to talk to the state of Nevada regarding the treatment. It allows the medical treatment providers to testify at a grand jury, all of which is a violation of the privilege.
So I agree that the order is broad, overbroad, and I believe it needs to be limited. So with that said, what would you propose?
Well, Your Honor, the statute expressly says that they're entitled to the records of the blood test results. So the order should say that the University Medical Center is authorized to produce the records related to blood test results only. The statute also says under subsection 3, records made available pursuant to this section may be presented as evidence during a related administrative or criminal proceeding against the patient. It's effectively a custodian of records certification built into the statute. So if UMC produces those records to the state is permitted to use those records during a criminal proceeding. They are not entitled to testimony. The state's concern that perhaps there's going to be surrounding circumstances that need to be explained is something that Mr. Ruggs gets to decide because it is his privilege. He has not waived it, and at this point in time is not waiving it.
State.
Your Honor, the state disagrees for the reasons laid out in our briefing.
Okay.
There's additional argument I would like to make though, however, because there is a second motion here that was made on the behalf of the alleged victim in this case. Her counsel is not present for this proceeding. I am prepared to argue against that motion as well if the court would like to hear it, but I think I laid out.
I don't believe we're going forward on that motion today. Mr.
That's
Schoenfeld?
not my motion, Your Honor.
How can we not go forward on that? The state, we have a preliminary hearing next week and we need to know if we're going to be allowed to have those records. It's calendared for today. Counsel for the victim was informed that it was calendared for today. Not only did he violate the
counsel for the
briefing,
victim?
Pete Christiansen.
He was notified of today's hearing?
He was physically present.
Madam Clerk? So what is the state looking to do relative to that motion? Argue and have the court rule on it?
The state would like to really
For Pete?
wait. Both sides have provided what I think is more than adequate briefing to render a decision.
Your Honor, we don't represent the individual that filed that motion, but we can try to reach out to her
Yeah,
counsel.
as a courtesy to the court and to the state.
Relative to Mr. Schoenfeld's motion, I'm going to take it under advisement and make a ruling by the end of business today. So relative to Mr. Christiansen, we'll try to get a hold of him. I'll trail this file, see if he wants to make an appearance so we can argue that motion.
Thank you, Your Honor.
Thank you, Your Honor.
Have a good day.
And Your Honor, the ex parte order was stayed pending this hearing. The stay will stay in place.
Pending my ruling.
Thank you, Your Honor.
So let's review what Christiansen's doing.